My name is David Crow. I'll be acting as the chairperson for the Zoning Board of Appeals tonight in place of Noah Eisenhandler, who is indisposed tonight. I'd like to take a few minutes to introduce people around the table to you. First off, good evening to the citizens of Orange who are here tonight and those of you out in TV land.
TV land.
Good evening. We could do better. I know it isn't church, but we could do better than that, people. All right. So, as I said, my name is David Crow. To my right is Wayne Garrett and Pat Panza. To my left is Greg Natalino and Eric Orzel. We also have with us our zoning enforcement officer, Jack Demersion. We have a new member tonight, or a new person with us tonight, Jenny Bowser. Am I pronouncing that correctly? I want to welcome Jenny Bowser to the fray. And we have our ever stalwart recording officer, Bonnie Sayat, working with us tonight. And thank you to the technical people in the back who make this possible to send out an OGAT and entertain everybody. Tonight we have a special meeting, and we thank you all for attending. I just want to go over a few things with you. I understand there's a lot of people here tonight, and there's some passionate viewpoints. Everybody will be given a full and fair opportunity to speak. However, you have to be recognized by the chair and do it from here. Yelling across the room or trying to shout over somebody is not evidence and will not be listened to. Okay, we will listen to everybody before we make our decision. I promise you, you will get a chance to speak if you want one. Okay, we ask for your cooperation on that. It's hard for the board members and I to render a decision and find facts if we're hearing people shouting over each other. It's hard for us to figure out what's going on. I'd also like to welcome a special person with us tonight, Vinnie Marino, who's the town attorney, who's going to be here to advise us and work with us on this. I'd like to start by asking Jack, we have a proper application in front of us, correct?
Correct.
It has been raised by Wayne that there's no A2 survey with the application. Is one necessary here?
Not for an appeal to my decision. This is not a variance request or a request for any sort of development, so an A2 survey would not have been required.
Okay. And we have a timely application?
We do, yes.
Okay, and we're having our meeting within the time allotted?
Yes,
All
sir.
right, and proper notice appears to have been given, I will assume.
Correct.
Okay. Pat, at this point, first off, gentlemen, I'd like you to ask everybody if they had a chance to review the minutes of the last meeting.
I did.
Any corrections to be noted? If there are none, I'd entertain a motion to accept the meetings as presented, or minutes as presented.
Second.
We have a motion by Wayne and a second by Greg. All in favor?
Aye.
Aye. Okay, so the minutes are accepted. Thank you, gentlemen. With that, Pat, if I could have you read the notice into the record, please?
Yes, good evening, everyone. The Orange Zoning Board of Appeals special meeting, public hearing, Monday, July 29th, 2024 at 7 p.m., lower level at the Orange Town Hall, which is located at 617 Orange Center Road. The minutes which we have reviewed, which was on Orange Public Access Television, the Optimum Cable Channel 79, Frontier Channel 6063, and Orange Public Access YouTube live stream. Note, residents may send questions or comments regarding the access to the public hearing to jdemergen@orange-ct.gov. The agenda this evening is to review, and we did that already, reviewed the minutes, and now the public hearing, and the hearing is listed as follows. Petition 1832 submitted by Michael J. Clemens Properties LLC for the property known as 217 Derby Avenue, a petition in order to issue the petition on an order issued by the zoning enforcement officer has been submitted.
Thank you, Pat.
You're welcome.
On behalf of Noah Eisenhandler, I'd like to read in to the Orange Zoning Board of Appeals, Town Hall, 617 Orange Center Road, Orange, Connecticut, to appear one time on Tuesday, July 16th, and one time on Tuesday, July 23rd. Orange Zoning Board of Appeals, notice of public hearing. Notice is hereby given that the Orange Zoning Board of Appeals will hold a special meeting on Monday, July 29th, 2024, at 7 p.m. at the Orange Town Hall, 617 Orange Center Road, to conduct a public hearing on as follows. As Pat said, petition number 1832, submitted by Michael J. Clemens Properties, LLC, for property known as 217 Derby Avenue. A petition of an order issued by the zoning enforcement officer has been submitted. Application materials are on file in the Orange zoning office. A copy of this notice has been filed with the Orange Town Clerk, dated at Orange, Connecticut, this 15th day of July, 2024. Noah Eisenhandler, Chairman, Orange Zoning Board of Appeals. On his behalf, David Crow substituting for him. So with that, I'd like to begin the public hearing. Anybody, we have a presentation on behalf of, hey, that's me. A presentation on behalf of the property owner. If you could just identify yourself for the record, sir, we appreciate it.
Yes, my name is Attorney Dominic Thomas from Cohen and Thomas, 315 Main Street, Derby, Connecticut.
Welcome, Attorney
And-
Thomas. Thanks for being with
Thank
us
you.
tonight.
Just to correct that, this is obviously an appeal. There are no petitions or applications to file. This is appeal. You're acting in your quasi judicial capacity as opposed to how you would act if there were a variance before you and other things.
Thank you.
And upon receipt of the cease and desist letter from your zoning enforcement officer, we appropriately filed an appeal within the time frame. I do, and I'm trying not to spill things from here, I do have some handouts. I don't. Hopefully they will cover everybody. I wasn't sure the number I would need.
Thank you, Attorney
So
Thomas.
if I could
Appreciate it.
Pass these around. Gotta keep one for myself. Two. Yeah. There's gonna be two there. There's a third one for,
You want to just pass them down this way and we can do it?
okay.
We'll do it for you.
Okay. You can over that way. and
Thank you,
the rest
Attorney.
can go over that way. I think there should be one for you then, and I have. Thank you. Huh?
I think he's going the other way. Thank you.
I think I have enough.
Yeah, you can give one of those to Vin. Yep, we got plenty.
I think we're all set.
All set?
Do you need one for the record, Bond?
No, I'm fine.
Okay, thank you.
I have an extra one if you have it.
Thank you.
Thank you. So, again, this is appeal of, on a cease and desist order, and I'm going to, hopefully, I'll be short, but I want to just give you a little background. On the site, Nicholas Thomas lived in West Haven and operated eventually purchased property in Orange and operated a little gas station that is now the house on the property. His son Ralph Thomas worked with him, and I believe, from my history, was a self-taught auto mechanic. And in 1945, when they were operating in early 46, he applied to the town of Orange for a variance to relocate the gas station to a new building, and also to, in addition to selling gas, to do mechanical work on vehicles. In September of 1945, one of his other sons, Dominic, returned home from World War II and joined the family business, which they wanted to expand, as I said, to include repair. In January of 46, they applied to the ZBA for a variance, which was granted, and that is the top document in the documents that I passed out to you, is a copy that was provided to me by your zoning enforcement officer of the variance. And just a point of, 6 months later, I was born, because I'm Dominic Thomas's son. And so I have some personal knowledge of the operation of the gas station, much to my mother's dismay, but I had some personal knowledge of it. So, as you can see, they granted, and it's important to read this, and one of the focuses of the appeal and of the cease and desist order relates to the phrase that it says there is extended to cover light repair work, but that the term light repair work shall not be construed so as to include any dismantlement of motor vehicles except for the dismantling of motor vehicles for the purposes of tune-up. It shall not perform any body or fender work, nor any painting operations, nor the receipt, storage, or repair of wrecked or junked motor vehicles. So they were clear. In order to properly understand an order like this, one needs to be realistic and put themselves in 1946. I was in a crib then, but you can read history as to what it was like, and you can know what it was like with the cars and the vehicles and what they were like. The point is that, in fact, they began operating it, and when you read down further, okay, is that they felt that this was an appropriate use. And it says in there, they voted that the findings of the board upon which they're based their granting of Mr. Thomas's petition are that the extension of the existing commercial establishment, remember the house was from what I understand, was a gas station, pump gas. You know, there weren't a lot of them around at that point. I'm sure it wasn't a Cumberland Farms. And the welfare and appropriate use of the adjoining property will not be substantially or permanently injured, thereby if the use is restricted and set forth as voted. The property, Mr. Thomas and the adjoining landowners, is all in a substandard development started and laid out before the adoption of the zoning ordinances. I read that. I had to read it a couple times to understand what it meant, but I assume what it meant is that area predated zoning, including the residences, and therefore there was a lot of non-conforming areas, but that's what it seems to be saying there. And then on the back, it says that not to allow the moving of buildings on location thereof as set forth in Mr. Thomas's position would be to impose on him an unnecessary hardship, having in mind the substandard character of the land developed upon which the buildings stand. So at that point, the building, and you have a packet of photographs, the building that's in the front of it, and you're all probably familiar with the site, that you see, that was the main building. It was and did have, from the very beginning, lifts. Lifts were authorized. So when you consider the term light repair work, you must consider the term that they authorized lifts to be in the building at that point. And I really, when you're talking about light repair work on the cars and the mechanisms of the cars at that point were substantially different than the ones we have today. Not only that, but they were substantially different than the ones 10 years later, a decade later. Cars were rapidly increasing as to what their uses were and everything like that. So in the photographs of the pictures, what you see, the front portion of it, if you're looking at, for instance, the third picture, and you see the cars parked off to the left, you see the gas station in the front, and you see a garage entrance to the left of the front. Well, that was the garage entrance that you pulled into where the lift was in the front portion, the 1946 portion, we'll call it. And that was it. The cars you see on the left and the cars that you see portions of it on the right, some of them, I mean, really, during most of this time, there were only two employees. There was my father and my Uncle Ralph, who was called Gigi. He was the mechanic. And as the business grew, and it grew rapidly, they had a couple of other mechanics. But please do not think of it at that point as a place where you had 10 people like working in the Lexus or the Chevrolet parts department and repair. It was not like that. Those were the only employees. Occasionally, as you got into the late 50s, I would get brought down there to pump gas or to help my father clean something, occasionally, but very, very rarely. And there were not many people. Mostly the people that hung around were the customers. And the cars you see out there were the cars that were being repaired because there was not much space inside the front building when they were worked on the front building. So then, in 1955, my father and my uncle returned to the zoning board, and they asked now, because the business was substantially growing, they asked for an extension to build, they asked for permission, to build a 50 by 100 foot building. Now, they also had another motive at that point, because sometime during that period of time, the state had refined, as repair places were growing, the state had refined its repair licenses. And the repair licenses we're now connected to, in some instances, the license to sell used cars. And also, at this point, there were more car dealers coming on board. So, again, the gas station was very popular, very involved in the community. On this end of Orange, it was the only place to go, basically. And my father and uncle decided, were hoping, that they would be able to not only build it to serve the people, but if you look at the last picture, and these are 1956 pictures, as you can see. If you look at the last picture, you see that to the right now of the old building, in the new building, there was a large glass front. That large glass front was there in the hope that they would be able to sell used cars. And that never materialized. They were never allowed to do that. But in the back, the permission was given, and I don't think I have it in the packet, but I don't have it in the packet. But your zoning enforcement officer, when he checked the file, and I'll be honest with you, I checked home files and photographs, but I couldn't find anything more. And he did not find anything. There was a court case involving this, and it did make reference to documents and a zoning approval in 1956, or 55 or 56. I think it was 55, I'm pretty sure. And he didn't make any reference, he didn't find anything to that. What he did find was 2 building permits, the most significant of which was an application for a building permit under a zoning ordinance, which allowed the 50 by 100-foot building, and it says use of the building, repair of autos and trucks, and it was approved by the Zoning Board of Appeals on January 10th, 1955, and it was a 5,000 square foot building. At that point, the back area, if you do the research, was authorized to have 3 lifts. So what you can understand is that there were now 4 lifts in the building, 4 hydraulic lifts. So when you're looking at the term light repair work, I think you've got to understand what that's talking about. Did my father do transmissions? No. My father, they never did transmissions. They did not, as the work of body work, they did not do body work. They bang out. You know, when somebody came in and they needed to bang out a dent or something like that, I do recall a couple of instances when he had to bang out dents that my mother caused in the car, you know, occasionally, and straighten them out. But that's the kind of stuff they did. They repaired lights. They, you know, if you hit a corner and you broke your rear tail light or something like that, they would fix that. Never did body work, and that was not something. Nor did they ever have paint boots or anything like that, other than the kind of little things you would touch up stuff or something of that nature. But they did a substantial amount of repair work. They did not do transmissions. They did not rebuild engines or anything like that. They did the work as it evolved now, 10 years later. Light repair work, what tune-ups? Tune-ups meant taking and replacing pistons, you know, these are the kind of things as it evolved 10 years later. And that's the kind of work they did. And they were very successful. They had a lot of customers. They had a lot of people. In and around that time and thereafter, and one of the things you would note in all these approvals, there was never any restrictions on the hours of operation. My father, before I reached like 5 or 6 years old, my father worked 7 days a week, 12 hours a day. And then at that point after that, he did take Wednesdays off. And so and the same thing for Ralph. They brought it in. They worked all the time. They had much stuff. My father, his extent of the repair work was doing the tire replacement and other things of that nature. He was not a mechanic per se. So as they got into the 50s, they hired mechanics. And as they got into the 60s, they had, I think at the peak that I can recall, they had 3 mechanics working for them. So it was mechanical stuff. We can argue what light repair work is, but I think you have to read it in terms of, number one, your zoning people back then approved 4 lifts. And this relates, I think, something to my appeal. The appeal, which is also in your packet, There is the appeal with my notes on it. And the appeal states, in the appeal, the subject property received the variance approval in 1946 to include light repair work, but did not include any dismantlement of motor vehicles for the purposes of tune-up. It actually did. Go back and read it. It said in there that the actual language is, light repair work shall not be construed to include the dismantlement of motor vehicles except for the dismantling of motors for the purpose of a tune-up. Again, read that as if it were 1946 and how tune-ups and everything evolved as you went along. Believe me, the town of Orange knew what was going on because my father worked, I don't know if he was the only one, he did the police cars. He didn't work on fire trucks because they didn't work on big trucks. But he had a relationship with the police, he had a relationship with the fire department, everything like that. I know he had a relationship with the police, very strong, because if you remember High Ridge Road in Orange, when it was being developed, it was a great place to go parking in the late 60s, which I did with my late wife, and got shooed out of there by a Orange police officer with a spotlight. And the next night at dinner, my father said, "What were you and Sally doing parking at the end of High Ridge Road?" Last time I ever parked in Orange, and anything. But he had that kind of a relationship. He worked closely with them, and he did repairs on the police vehicles. They also had a tow truck, and there's one of the tow trucks is in the picture. They had a tow truck that they used, obviously, as they grew up, my father, and occasionally he operated it. I think maybe once I got a ride in it. And so they would tow when one of their customers, and it was very customer-oriented, did it, they would bring the car and tow the car in for service. Other times it got towed for other, cars would get towed in there by other towing companies. So that's how it evolved. One interesting point, and when you talk about, and I talked about it in reading through this, is, and I was getting to this, that there's no mention made of hours of operation and everything like that. In the mid-'60s, I think it was, mid to late 60s, my father, much to the dismay of my mother, was going to open the gas station 24 hours a day, not the service portion, the gas station, 24 hours a day, 7 days a week. The reasoning was they had just announced the plan to build the connector from 95 all the way to connect with 34 at Maltby Lakes. So if those of you can vision the entrance that there is to whatever's back there now, Yale, something or other back there now, that was where 34 was going to come in. It never materialized because nobody was going to let the state take eminent domain, Yale's ball field, and the cemetery. That's what it had to go through to reach that point. But I'm bringing that up because even working with the town at that point was interested in, oh, that would be great if you were open, the gas station, because that was going to bring more traffic in towards Orange. And so, and there was also some opposition to that, but it never materialized. Now, one of the last thing that I think I have in your packet, and which is very interesting, the injunction that was written, which prohibited body work, which prohibited paints, which prohibited the painting the junk cars, was written by Judge Robert Fuller. And for those of you, I know Vin has no issue with, will know this. The Bible book written on zoning is called Fuller on Land Use in the state. So Robert Fuller also writes the book. And I have been involved in numerous substantial cases involving non-conforming uses. And so I gave you, and I don't mean, I gave you the entire section, 552.3, on extensions and changes. And I just want to point up a few things. I'm not saying that, but the issue of how a non-conforming use evolves. He points out in the very first paragraph, using improved, more efficient equipment and modernizing non-conforming uses as permitted as long as the improvements are used to pursue the original uses. So I'm going to state for you, right off the record now, that the issue of storing junk cars was never done by my father, my uncle. It was never done in the business then. There were cars, as you see in the picture, stored outside. Those cars that were stored outside were cars that were either waiting for parts or they were being repaired and they didn't have room to maneuver them inside. Even though you had 5,000 square feet, you still wasn't able, they would occasionally park cars inside there that were waiting, but they had a very active business, so cars would be parked outside. Normally, the cars that were parked outside that were being worked on in the back would be parked on the right-hand side, because that's where the driveway went into the back, into the biggest garage door. It had 2 garage doors. The cars that you see that were parked in front of the house, that would often be potentially my father's car or something like that, but also cars that were being worked on in the front area. So that's how that they operated. But they never did junk cars. And in talking to my client, and ever since I became involved in this case, I think in March or around then, I've told my client that he needs to address the issue of the junk cars. And he has been looking since then for an alternate site to take care of the issue of the junk cars. And in fact, I was informed tonight, his son's here, my client isn't here, he has health issues, but his son is here. And that in fact, just about all of the junk cars are gone or will be gone. And the cars that are out there in the area that I think is currently fenced in are cars waiting for parts and waiting to be finished service, finishing service. But I think the reason I gave you the Fuller thing is the issue of what they do with cars. They do not rebuild engines. But so does light repair work? They do tune-ups. When you're doing a tune-up, you could have to replace a piston. When you're doing a tune-up, you could have to address other issues. If it gets to beyond them, it goes. If it requires an engine buildup, then they, as my father, have to send it out. If it requires transmission work, it goes out. My father never did transmission work. Mr. Clemens, and the operator of the repair places, never does transmission work. My father had a single tow truck. Well, towing has changed. You look at there, and it has expanded. If the tow truck is connected to the storage of junk motor vehicles, yes, that might be an expansion of the nonconformity, but my client is making every effort to comply with that. My client does not have paint booths inside. He does not do body work other than related to minor repairs that you would normally do. He has no equipment to engage in the modern body work system that operates. The cars in 1946 and even in the mid-50s were easy, were all metal, and were easy to, not easy. You could bang out a little dent or something like that. I can remember even people putting the plunger, your bathroom plunger, against the dent and try to pop the plunger out. You can't do that these days. There is great technique. Body work is well above him, and well above what is being done now and what was being done then. And when you go through the Fuller thing, the one thing I want to point out to you is that in addition to using better equipment and everything like that, and to trying to define what repair work is, what tune-ups are, in 2024, as opposed to what they were in 1946, he refers to some cases. And one of the most interesting cases is a case called ZACHS, Z-A-C-H-S. It involved a situation of a cell tower, I believe, or a communications tower that was either a pre-existing legal non-conforming use or a variance within an area. And now they wanted to put a generator and other equipment. And it allowed, they said that putting the generator and expanding the area of use of the radio tower, I'm sorry, it was a radio tower, that it was permitted by the court, and it was upheld in the appellate court. And it said that in deciding whether the activity in question is within the scope of a nonconforming use, consideration should be given to 3 factors. Now, I've already said to you, I'm not going to stand here before you and argue that the storage of junk motor vehicles is an expansion of the nonconformity. And my client has been taking steps and apparently has a temporary location where he's moved them, and he's taking steps for a permanent location. But the three factors are the extent to which the current use reflects the nature and purpose of the original use. So number one, what was the original use? The original use was permitted for auto repair. It said light repair. It authorized a lift. So it obviously, that was within the definition of the ZBA at that time. They authorized a lift. And it said that for the purposes of tune-up, you could dismantle a motor vehicle, an engine. So you've got to read it in those terms. Number two, any differences in the character, nature, and kind of the use involved? Well, I don't think there's any difference when you look at the modernization and how it's changed, keeping in mind that I'm not standing here arguing to you that we could store junk cars there. That's not the point. But when you look at other uses, any difference in the character, nature of the use involved. And three, any substantial difference in effect upon the neighborhood resulting from the differences in the activities conducted on the property. This one, I will stand here and tell you that, no, I don't think there is. I mean, when you look at the impact, again, aside from the issue of the junk cars, it's a service station operating, and it's been a service station operating. I don't know what they sell inside the front, but I can tell you that my father sold candy, soda, milk, candy again, because that's when I would go there. That was my pay, was being able to get candy from the vending machines, which were cool to take that, and the old-fashioned ones. But that was what happened down there. And they did repair work, and they repaired cars. Again, when it got to a level that was beyond them, when an engine had to be completely disassembled and rebuilt, that was it. When they had to order parts to fix an engine, yes, they replaced the parts that were in the engine. That's what they did, and that was part of tune-ups and repair work as it is. And if they didn't, if that wasn't intended, then you tell me why the ZBA in 46 and 55 authorized 4 lifts. Back in those days, they still had the hand lifts. So if that's all they wanted them to do, they could have just authorized that. But they authorized hydraulic lifts. The other thing that makes this a very interesting statement in number 3 is the statement in the 1946 variance that talks about the existing neighborhood. But the existing neighborhood has changed over the years. The biggest change in the neighborhood that I can tell you that I recognized as a young person is when the junior high went behind the school, and the impact that had in the whole neighborhood, but also on my father's business. So what I'm saying to you is, when you look at the zoning and when you look at the cease and desist order, which I have to make sure I find, and when you look at which I have appealed, okay, in the cease and desist order, there is a notice of violation, and the subject and it talks about you are hereby warned that any motor vehicle repair or similar activities beyond the limited repair work authorized by the 1946 violates the Orange zoning regulations, even as repair work which a licensed repairer may perform after 1451. Well, number one, in addition to the fact that you have a misstatement in the second paragraph concerning the dismantling of motor vehicles, my point is that you cannot say it is completely unreasonable from a legal perspective to look at this and say, I'm sorry, you can only do what you would have done to a 1945 Chevrolet and something like that. And that's as far as your technology would go. You can't, I'm sorry, you can't use computers. I'm sorry, you can't use, you can't look all of these things, all of these electronic testing devices. I'm sorry, no, that's ridiculous. The fact is, you have to read it in terms of what has transpired with respect to repair work over the period of time. But keep in mind that the repair work takes place inside the building. So it has no impact on the neighborhood. And that is what was done. We're not talking about, I don't want to Did my father change a tire outside? Did they do some work outside? Of course they did, when they needed to. You jack it up self and change somebody's tire or something like that. But the repair work was all done inside. Secondly, the second item is the receipt, storage, or repair of wrecked or junk vehicles. As I told you, my client has eliminated it to, I think from the statements tonight, that they're all out. The only thing in there are vehicles waiting to be repaired. The performance of body or fender work, including any painting operations, violates it. It is not an auto body shop. They don't do it, but I'm being very frank with you. Yes, if you walked in there, if you drove in there and you had smashed your rear tail light and you needed to get the rear tail light fixed and hooked up, he would, I'm sure Mr. Clemens and his people would repair it, my father would repair it, and if you needed to hammer out your edge. Is there any body work being done where the kind of equipment that you have in a body shop? No, absolutely not. Is there a paint booth? Absolutely not. He's too smart to realize that if you put a paint booth in there, and I think Attorney Marino realizes this too, you then come close to declaring it as an establishment the minute you do that. So most people wouldn't run that risk. So with that, I believe my client, number one, I believe the cease and desist has some errors in it, especially as it relates to repair work. Number two, with respect to the other items, number one, my client has never done the body work or the true body work or painting other than minor things related to repairs. And finally, he has ceased and will continue to cease and will permanently remove any of the junked or stored vehicles. So thank you, and hopefully you enjoyed a little bit of the history lesson, and I'm here to answer any questions that you have.
Attorney Thomas, I just want to clarify. So with regards to 2 and 3 in the cease and desist order, your client agrees he has to comply.
Oh, yeah, he's number
those issues.
number 3, number 2, he is complying by removing it since the time. Number 3, he doesn't do body work.
Okay. And I just remember to
And
turn
we'll-
my microphone on because the wizard in the back just waved at me. And so we're down to an argument on number 1.
Yes.
And your argument is that you are expanding
Well, we're
not expanding, but,
It's the logical sequence of what light repair work was. I mean, if you're not, I think the interesting thing is, then define it. Define what you're talking about. In today's day and age, as it's interpreted, and also under the terms, when you've got to go back to the language in Fuller, when it talks about using improved, more efficient equipment and modernizing non-conforming uses is permitted as long as the improvements are used to pursue the original uses, was to repair motor vehicles.
okay.
So that's my point. We don't do anything. Again, he hasn't expanded into transmission work, which is, as you know, has evolved into a completely separate automotive type service. You have transmission places. He does not rebuild engines from scratch. Does he replace parts when you're doing a tune-up? There's a problem with your piston. I'm going to order a piston. I'm going to replace it. Is that part of a tune-up? Of course, it generates it from that. The other thing is, back in those days, you went in there and you had to take things apart and try to run it and everything like that. In today's modern day and age, you hook it up to a computer. And the cars, most of the modern cars, will then tell you what's wrong with them. And then you've got to repair them. So you can't compare it exactly to whatever light repair work is. But what I stress to you is, if light repair work was just changing tires and doing some oil changes, then why the heck did the ZBA members in 46 and 55 authorize lifts? You don't need lifts to do either one of those two things. You could have changed oil just by jacking up the front back then with those cars and changing oil. You did not need lifts to do that. You needed them to work on the engines and the portions of the engine. So there was 1 lift in the front from 46 and 3 lifts in the back from 55.
Attorney Thomas, I'm looking specifically at your second photo in your packet. It says photo taken on May 13th, 1956. And there's a bay to the left there. I see it says number, I guess that's the 350 is or no, that's Esso. To
Esso.
the left of the Esso, it says over the bay. lubrication.
Right.
Right. Right, that was the front one, and it said that was, that they would do lubrication in that area. They would lube up your cars or anything like that that took place back then. You also got your tune-ups done in that area. There was an area on the other side, the cars could also enter and go in, but it had no lift. It does say lubrication, and you'll notice right next to that is the tow truck. And there was also a Jeep with a plow.
Thank you, Attorney Thomas.
Okay.
Any other board members have questions, please ask them now. Also, remember to turn on your microphone. Don't do like I did and leave everybody in orange wondering what I'm talking about.
Yeah.
Go ahead, Pat. You got a
Attorney
question?
Thomas, how are you?
Good.
Couple questions. You know, again, back in those days, 46, 54, you know, when they talk about the lifts, as you speak of, yes, they had lifts to do oil changes. They didn't basically roll underneath the vehicle to do the oil change. They lifted them up. So I think the intent back then was, yes, he wanted to expand. Maybe they thought he was expanding his lubrication portion of his business. Anything's possible. But I understand where you're coming from. But I also see, you know, some other issues that might be a problem. The next question I have is the Rex. I don't see any kind of contaminant control on the property. In other words, you don't have any containments that if the Rex are there leaking oil and stuff like that, how's that contained on the property? How do they handle it?
They've removed the wrecks. They don't do it.
No, I understand that.
I mean, as to what's on the property, I'm not aware of any issues that they've had with respect to any issues. I can consult, Mr. Clemens' son is here. He may be able to answer your question with respect to that. But again, they have taken the,
Then let me follow up with another question. The number of wrecks that he's had, or vehicles that you would consider that were waiting for parts versus the vehicles that were brought there that were damaged, that were not drivable, that was going on for how many years?
I couldn't answer. I have no idea. I'm responding to that. I understand that the bringing of the wrecks was there for quite a while, and that's why I have, you know, talked to
Okay.
my client about resolving that issue.
So it's safe to say that the property itself may have been in jeopardy of a contaminant. Is it safe to say that?
A lot of properties, your own property could be,
Well, this
if
is
you park,
true.
if you park outside, everything like that. But as far as I know, there is no evidence of any spills that require any reporting to the DEP or the town of Orange.
Okay, thank you.
Eric, do you have questions?
Yeah, no, I was just reading page 3 here, back in 1954, when he applied for the zoning. So it said that they were gonna install 3 car lifts and a front-end machine would be installed. So being a front-end machine, it seems like the town back in 1955 approved 3 lifts and a front-end machine.
Yeah.
So, you know, at that point that, you know, the town said, okay, you could do, you know, front-end repairs. You know, that's the way I've,
Right.
you know, I'm reading that, and.
Which they did on the police cars.
Right,
And-
exactly.
I mean, they worked on, you have to understand, they worked on town vehicles.
Right,
You know,
right.
and, much to my dismay,
Right.
that they worked on that, and they were involved in that, and,
Which is like repairs. and-
yeah, right, I
Yeah.
mean, I.
Just part of
Yeah.
maintenance of a vehicle. You know, you need a front-end machine to do that and, you know, make those maintenance repairs. I mean, it's just
Exactly.
part of owning anything that's mechanical,
Right.
so.
Ben, do you have questions?
Before you get yelled at, turn on your mic so
I did. It's the green light's on. so-
Don't forget my mic.
You want me to speak louder?
Tell me if you're not hearing me. Okay,
Thank you,
thank,
perfect.
thank you. And for the record, it's Vincent Marino, the town attorney. Attorney Thomas, can you explain how you believe Justice Fuller's decision, which was in 1991, which is well into your evolutionary argument of progression of automobile light work repair. 1991, some 40-plus years after, or 50 years after the variances are granted. And Judge Fuller enters a permanent injunction and issued against the defendants, who are the property owners, from carrying on any auto body or fender repair work or painting operations, from receiving, storing, or repairing wrecked or junked motor vehicles or any other automobile repair operations other than those, we want to emphasize, other than those by prior variances granted by the ZBA. So Judge Fuller seems to argue, again, 1991, and presumably your argument should have or could have been made available or argued by the defendant in this appeal.
Well-
And if it, let me just finish so you can hear my complete thoughts. So can you explain two things? One is, how is this body not bound by the permanent injunction issued by Judge Fuller, don't want to elevate him, Judge Fuller, in 1991, number one, and number two, how is the appellant in this proceeding not barred by the doctrine of res judicata, since he had a full and fair opportunity to litigate this in the 1991 appeal, which this town was a party to, and which your client was a party to?
Well, you are absolutely right that with respect to auto body or fender repair work or painting operations, from receiving, storing, or repairing wrecked or junked motor vehicles, my client, and I'm not claiming at all that that's in any way an evolution with respect to it. My client is not involved with that. The next phrase is, and any other automobile repair operations other than those allowed by prior variances. So what do we have? We have prior variances in which, as part of the variances, number one, light repair work was authorized, and that light repair work required a lift in the original one and required the dismantling, or allowed the dismantling of motor vehicles for the purposes of a tune-up, whatever that was in 1946. In 1955, the variance then allowed, as was stated, the variance was allowed to have 3 more lifts and in fact, other equipment related to repairs. So with respect to the language of other than those allowed by prior variances granted by the Zoning Board of Appeals, I think when you look at the prior variances, what was allowed by the prior variances, what was addressed, and the fact, as Judge Fuller has said later on, that you can't have an evolution. There's no, when you read the entire decision, and I know nobody wants to go through all, whatever, pages of the decision at this point, but if you read through the, some of the interest in talking the decision, the main focus seems to be on the issue of the junk cars and the auto body. But I think that when you look at that last bit of language that is in there, it fits in exactly with my argument, that in fact, when you look at the evolution, I don't think Judge Fuller clearly was saying you had to only do repairs that you could have done on a car that was 1955 or
And
earlier.
that's my concern, and I want to give you the
Yeah.
opportunity to
Yeah.
respond to my position is that Justice Fuller, again, I did it, Judge Fuller was very specific when he issued the permanent injunction to say that they're limited to the repair work granted in the variances by the ZBA. He didn't say, as may be evolved over time. And so, since the town has to, or this body needs to be aware of the permanent injunction and the implications of that permanent injunction, so that its actions through this body are not in violation of that permanent injunction, right? And it is not acting illegally, arbitrarily, and capriciously. Since Judge Fuller specifically says a permanent injunction is issued, and specifically references the variances granted by the ZBA. So this body goes back and looks at the languages of those ZBAs back in, the 40s and 50s. Now you're saying, notwithstanding what it says, evolution. But 1991 was well into your evolution argument, and Judge Fuller doesn't address it And the defendant, the appellant in this matter, had the ability to make that argument before Judge Fuller, but either did and it failed, or it failed to raise it, and therefore is barred by res judicata from you raising it today.
He didn't have to do it.
Why?
Because it wasn't raised by the town in the injunction.
Oh, it's res judicata.
It was not raised by the town in the injunction. Read page 4 of the decision. The town claims that some of the repair work and business uses now carry on the site, namely botting and fender work, painting and repair, and storage and repairs of wrecked or junk motor vehicles violates the zoning regulations. There is nothing in here that references the town complaining that the repairs on the vehicles was violating it. The judge simply stated the obvious at the end, which is you can't do these other things, and you can only do what was authorized in the permit, which was light repair work. He didn't say, or the evolution, he didn't have to address it, because according to this, if I'm reading it correctly, and I don't have the evidence, that was the application. It had nothing to do with repair work was taking place inside the gas station at the time. And that's what I garnered. I granted, in 1991, I can't get back like I can with modern day and look at the record, the case detail, or anything like that, and I didn't go to Iron Mountain to find it out. But I read that, and that makes no reference at all to the repairs taking place inside the building. So what was said in the last paragraph relating to the repairs and the variances would amount, in my opinion, to dicta at best, and not related to the issue at hand. The other two were clearly the issue at hand, and clearly, as I've said to you, those two things my client cannot do.
Well, the last paragraph on page 14 is not dicta, that's his decision.
Right, but what I'm
Right.
saying is the language in the last paragraph that references the repair work was apparently not before him, according to paragraph 4, when he stated what was the subject of the injunction that was proceeding. Now, again, I don't have what the thing was, but he recited, Judge Fuller recited, and on page 4, what the complaints were of the town. It makes no reference on page 4 to what that the town was claiming, that the repairs that took place inside were any issue. And frankly, I have no idea how the repairs taking place, other than body work and other stuff that you're talking about, how the repairs inside could, have an impact on what's occurring outside. They're doing repairs on cars in 1991, and apparently no one made a claim, and I would like to know what the claim would be. Is the claim that you are repairing a piston and you shouldn't be repairing a piston? Is the claim that, and I don't understand what the claim is. There's nothing in here that would have said that, in fact, in 1991, they were repairing transmissions. In 1990, which I don't know how that would have an impact even if they were doing it, but they were repairing transmissions in 1991. So in fact, when you look at the injunction, we are agreeing with the injunction, but how Judge Fuller worded it at the end, you have to look at what was before him. And he stated on page 4 what was before him. There was nothing before him dealing with repairs.
Well, but he states on page 12, the plaintiffs, which is the town, have proven that any motor vehicle repair or similar activities beyond the limited repair work authorized by the 1946 variance violates the zoning regulations.
Right.
So
And,
that's pretty specific.
right, but they're not, no, it's not specific. It has no,
What's unspecific
there's
about that
nothing,
statement?
there's nothing in there about what repair they're talking about. Where is the complaint? What is being complained about? What repair inside the building is being complained about?
If I may.
Yeah.
Gentlemen, if I may interrupt.
Just go ahead.
On page 3, it seems to me that the permanent injunction refers to prior variances granted by this board.
Right,
And there's 2 variances that I'm aware of. There's the one in 46, which says they're gonna vary the property for light repair work, not to be construed to include any dismantling of motor vehicles, except the dismantling of motors for the purpose of tune-up. Motors, and I assume that means the car, part that makes the car run. And then it goes on to talk about the parts that we already agree on, that, the junk cars and things that your client's
Right,
gonna comply
yeah.
with. The second variance was in 1954, which says the application stated that 3 car lifts and a front-end machine would be installed. There's no indication that the business operations would be extended. Okay, so those are the 2 variances. So we're down to arguing about whether or not we're talking about dismantling of motors for purposes of tune-ups.
Well, we also have 55, we have the front-end machine.
Mm-hmm.
So what was, in other words, I'm asking a very simple question. Tell me
I haven't
what
asked you a
repair,
very
I
simple
understand that,
question
right, but what is the limited, what is the repair work?
Well, I would say.
Is the subject,
Yeah,
what type of work?
It would seem that based upon the variances, as we're instructed by the injunction to observe, would be, and this, the relevant portion would be, except for the dismantling motors for the purposes of tune-ups. That would be
Okay.
my answer to your very
So
simple question.
all you can do is lubricate and dismantle well, obviously you can do a tune-up, and you can do a tune-up without dismantling. So the simple question I have, to make sense of this opinion, is what repairs are you talking about? Everybody has a car, so what repair are you talking about? The front-end machine would mean, back then, that they were apparently doing alignments, possibly. They were apparently checking front-end suspension. So the planning and the ZBA allowed that. So if you're allowed to do tune-up, what is the definition of a tune-up now? And what was the definition? Are you going to say that, well, the only thing you can do is what you would have done to a car in 1946?
Well,
and-
Judge Fuller seems to point us towards 1946.
No, he does not.
Okay.
He does not in his decision, please.
Attorney Fuller, I appreciate that you disagree with me.
Yeah.
However, I did ask at the beginning that people be allowed to finish their statements.
Okay,
If you just allow
go
me
ahead.
to finish my statement before you talked over me, I would appreciate it.
Okay,
Okay? I understand you're passionate about this, I understand you have an argument, I will give you every opportunity to make it, I promise you, okay? It would seem to me that Judge Fuller in his decision directs us to 1946, the variance of 1946 and the variance of 1954.
fine.
And in those variances, as I see them, it says, except the dismantling of motors for the purposes of tune-up. And then there'll be 3 lifts and a front-end machine. Now, I assume that what those 3 lifts and the front-end machine were to do is to facilitate those tune-ups and dismantling motors for the purposes of tune-up. Would that be correct? Would you agree with that statement?
I'm sure they were used in the repairs that were being done.
Okay.
I mean, you have to remember that none of those that you're talking about was before the injunction. Because in paragraph 4, it stated what the town's complaints were, and nothing of the town complaints does it define in there what repairs inside the building were being challenged as being in excess, other than the junk cars and the bodywork.
I appreciate that as an argument against the race judicata argument. I just wanted you to.
Okay, but-
That's how I understand.
Okay, so, and just so, the point is, judges can only render a decision on what's before them. And in page 4, he's telling us what was before him, what the complaint of the town was.
Well, I'm focused on paragraph, on page 14, where he gives us the language of a permanent injunction. And I know that this body has no authority to, it's not your assertion we have authority to ignore an injunction, is it?
No, that's why I'm telling you that we're not gonna do the other two, those things that are in the cease and desist order. In order for me to defend my client, I need to know what repairs you're talking about. And that's my point is, if your cease and desist order, maybe it has to be redone, but it is patently defective if in fact the repairs that you're talking about inside are not defined. I have no idea what repairs inside that building on motor vehicles you are talking about, other than painting and bodywork.
Okay, so your argument is that it's defective because it's not defined. The cease and desist
Exactly, right.
Defective is not defined.
Right.
Thank you for your help, I
Okay.
appreciate that.
Okay.
Vinny, you got anything to follow up?
No.
Anybody else, any questions? Wayne?
Good evening.
Good evening.
Wayne Garrick. I like to think of myself as a problem solver. And I think that ultimately, I understand the argument from David and from Vin. And I think that can be defined. But in order to cure the situation here, which our zoning enforcement officer has cited, I think we need some definitive answers from you and your client, which I'm sure we can easily respect, because I've been, I know everyone always says this at every meeting, how long they've lived in town, but I've lived in town 60 years. So from a teenager or child, I've seen that service station evolve to a certain degree. And recently, I can't remember exactly the date, but certainly the towing operation has become more intense. And I assume when they tow cars there, I apologize, I don't know to stop there, not a customer, but they must leave cars that have been in an accident or junked or wrecked in one form or another. So you've made a statement to our board that your client is in the process of, you mentioned removing the junked and wrecked cars. You didn't say anything about the towing operation, so I would be curious as to your thoughts whether that intense towing operation might be moved along with the wrecked cars. Let me finish,
Okay.
please.
Okay.
But my question to you is, what's the timetable? I know if I were a neighbor, which I'm not, but if I were the neighbors and I saw all these wrecked cars and I saw all these large tow trucks lined up there, from the one small truck from your photograph in 1946 to the 8 tow trucks or 6 tow trucks that may be there now, if I were a neighbor, I would be concerned about that operation. You've stated, so I think we need to know how you and when you intend to cure that number 2 on this citation. And secondly, you've also stated that there's no body work being performed or a painting operation, which is fine, but I take your word for that. But we need to hear from the neighbors, people who maybe observe what type of transactions happen there, more on a day-to-day basis, as opposed to some testimony, and how, if or whatever is being done with that, how that is going to be cured, and what your timetable is for that as well. I think what we're interested as a town, at least me, as a community, we're all part of the same town. We just want a resolution to a situation that is adversely affecting neighbors, and I'm sure their concerns are quite valid. So what would be your client's time schedule in order to cure these numbers 2 and 3 on your list here, on the citation? Sorry. Thank you.
Okay. As I stated, and it's my understanding, and like I said, my client's son is here, may be able to elaborate. I've had conversations with my client. He does the towing, and a lot of it is related to towing related to the town of Orange. He's the towns have them. So he's been looking for a permanent site. He has a temporary site, and I was informed tonight that the junked motor vehicles have been removed from inside the white container, white fenced area, okay? They are at a temporary site. It is my understanding from discussing with my client that a permanent site, and he's in discussions with it, because with respect to a permanent site, not only do you have to determine whether it's going to be a purchase or a lease, but the other thing is, you've got to make sure the site you go to authorizes, from a land use perspective, what is going to be done there. So once that is, and so that may very well be done. I had a conversation with the son tonight, so that may already be accomplished with respect to it. So once the storage moves elsewhere, the tow trucks would follow to that site, okay? Whether or not there be 2 or 3 tow trucks related to the repair motor vehicles, I don't know. Certainly an expansion from one to two, that just to operate the repair thing would not be a problem. I understand that any situation where someone complained that there were 8 and bringing in junk cars, that would be a violation. Again, the only thing I can say to you with respect to the body work is that the client has said to me very frankly, we don't do body work, we don't do auto body work. But he admitted to me, you know, if you came in and you had a dent or a fender, you know, a little dent, and we could pop it out ourselves and do that, yeah, we would do that, you know, for a customer, but no auto body work. If you're in an accident or anything like that, you're not gonna be, and they're not licensed with respect to insurance companies or anything of that nature to do that, but they don't do it. So I think we're in compliance on that, and I believe, based on the comments that were made tonight, they're in compliance with respect to removing the junk cars, if not total, you know, almost total compliance. That's in process to a temporary site, and I was told the permanent site hopefully would be resolved within the next 30 to 60 days.
Thank you. Yeah, I would agree, or I would like to state that I see the towing operation, and I don't see it as you characterized as a permissible intensification of the use of the site. So I think that does violate the variances that have been granted in the past. But now that you've stated, so can we, as the board, can we rely upon your statement that the towing and the removal of other cars and no new wrecked or junk cars will be brought to the site
That is the
in 30
representation.
to 60 days?
That was, in 30 to 60 days, that would be all resolved, yes. And as far as the towing operation, my point was, I didn't say that 8 tow trucks was I didn't say that. Okay, what I said to you was, my father had a tow truck. The fact that
I can see it in the
60
picture.
years from now, the fact that somebody has 2 tow trucks is probably a permissible expansion. Granted, I will say to you that somebody who has 8 tow trucks and is taking in junk cars would probably not be, and I pretty much admitted that, a permissible
Thank you.
expansion.
Thank you very much. I would agree with you.
Okay.
And Attorney Thomas, just on that point, I know you've represented that several times to the board, and I thank you for that.
Yeah.
I just want to make sure that those representations are based on testimony from your client, was a representation from your
Right,
client.
and talking to him, and again, when I get finished, I will have a further discussion with,
I don't want anybody thinking attorney, we're going to rely, hold
Yeah.
poor Attorney Thomas
well,
personally responsible to haul off the wrecks or anything like
no,
that.
I don't think you want to do that.
Did he
Probably-
follow up?
Yeah, Attorney Thomas, just again, for the board, when it's considering,
Can you press his button there? Thank you.
Move your mic a little closer. I'm sorry, it was David's mic.
oh, okay.
A lot of sharing going
Let's,
on.
we're all set with the mics? Thumbs up, thank you. Okay, so in trying to define this concept of light repair work for the board to, because the board has the ability to, doesn't necessarily have to reverse, it could modify the order of the ZEO. So in trying to come to what light repair work might include, when I'm looking at 14-52 and 14-50, I believe, 1. 14-52 of the general statutes defines repairer to include qualified persons with a suitable place of business and adequate repair engaged in repairing, overhauling, adjusting, assembling, or disassembling a motor vehicle. Now, what was obtained was a repairer's license, but it was limited to what was allowed by the variance, which is light repair work. Now, but that definition is not, light repair work is not defined by our zoning statutes, but a limited repairer license in 14-51 seems to provide some definition of this repair work that is less than what a repairer's license would be. And in your view, would that definition, limited repairer, somehow provide guidance to this body? Because that defines limited repair to include making minor repairs, whatever that means, including repairs and replacement of cooling, electrical, fuel, and exhaust systems, brake adjustments, relining and repair, wheel alignment and balancing, and shock absorber repair and replacement. So, which seems to be somewhat consistent with some of what you were arguing earlier of what was done on the property, maybe not wholly consistent. So I'm trying just, if asked, for what a light repair work might be. Is there, I could only look to the regulations of the
I'm trying to
statute.
understand the difference between the two definitions that you just gave. But
Well, again,
with all due respect, that's one thing my father never taught me, was how to do anything with cars.
Right.
You know, but
so, and that's what I want to know. So
Yeah.
so then light repair work, in your view, would be less than what the state defines as limited repair?
No, I don't think so. I don't see how it
If
could be.
The repairer license was approved to be located at this site by the ZBA back then, and they 1 month later, Judge Fuller's decision on page 8, 1 month later, when the board approved the location for a repairer's license, it authorized use of the premises for the light repair work allowed by the variance. So we're trying to get to what does light repair work include, and I just read you two statutory definitions, which you say you don't understand the difference, which would mean light repair work has to be less than the limited repair definition.
No, I disagree totally.
Why? How?
Because,
explain.
well, first of all, what you described in the light repair work, or in the limited repair license, was exactly what was done. I'm not sure I don't have the statute in front of me, but I mean, my father, granted, they had a full repairer's license. I know that they had that, but I don't know, listening to the definitions, I'm not sure what the extent of things in the first part, in the general repair license, how it differed from the language of what's in the limited repairs license contained probably everything that was being done or that has evolved from that.
Well, that was my question to you. Yeah, and that was my question to you, is that the general repair work seems to be broadly defined as the repairing, overhauling, adjusting, assembling, or disassembling of a motor vehicle. It just seems very broad. A limited repairer seems to be defined more specifically, not the complete dismantling of a motor vehicle, but could include minor repairs, including repair and replacement of cooling, electrical, and fuel and exhaust systems, brake adjustments, relining and repair, wheel alignment and balancing, and shock absorber repair and replacement. And so it's less than the complete, and seems to define minor repairs related to some of those activities.
And those were minor repairs. Now that you say that the general repair, I think under general repair, and I'm just saying, but from what you said, the general repair might have, if you had a general repairer's license, if that was allowed, that would have included body work, because that would have included disassembling of
Right, but-
the vehicle, and that was clearly not something that was authorized, because I think what was being talked about by Judge Fuller is the general repairer's license.
Correct.
Because I believe, if I'm not mistaken, the limited repairer's license came about later.
Yes.
The general repairer's license is what my father had.
Correct.
And,
Right, and so my question to you then is, because on page 8, when the ZBA acted to authorize the location of the repairer's license, so if you look at the bottom of page 8, in the final paragraph, it's a sentence that starts with 1 month later. It's about 4 or 5 lines from the bottom. 1 month later, when the board approved the location for a repairer's license, it authorized use of the premises for light repair work allowed by the variance. So it limited the approval of the repairer's license to the variance. Right?
okay,
So, you know, and we're trying to say, well, what does light repair work mean? And today, the state distinguishes between repairer's license and limited repairer's license. Limited repairer's license may be more than light repair work. It may be light repair work. I'm not here opining on that. But I'm asking you, you know, today that we have a statutory distinction between a repairer's license and a limited repairer's license,
all right.
right?
Well, okay, Judge Fuller is operating on what was before him.
Yes.
Okay, so to make everything make sense here, because there is no reference in this entire thing as to a definition or explanation or complaint as to what repairs were taking place inside and how that was a violation. So in fact, you go back to page 4 and you look at what the complaint was. I wish I had a copy of the actual complaint, but I don't. But you go back to page 4, and what was before him was the issue of body and fender repairs, painting of a motor vehicle, storage of wrecked vehicles. So in fact, if the general repairs license, and it sounds like it authorized body work and disassembling it, what Judge Fuller was saying later on is, no, you can't do that, because that wasn't allowed in the variance.
Correct.
So reading the decision as a whole and making the little excerpts we're pulling out make sense, you read it, you begin with, what was the complaint? And all I'm saying is, the complaint here doesn't say, I'm sorry, you can't do brakes. In other words, the complaint wasn't, you can't do brakes, you can't do alignments, you can't do, that wasn't the complaint, there's no complaint. It didn't mention that, it didn't mention in here. So when you read then how he was addressing the issue of repairs and light repairs, okay, I believe it was focused on the issue of body work, because it was connected to, at that point, I'm making the assumption, because I wasn't aware of it, at that point, the client was bringing in junked motor vehicles and apparently working on them, because that was the complaint. So let's take, for the sake of argument, we're going to assume that that was the correct application that was being made. And therefore, when you read the rest of it as it relates to that, then it makes sense. Because the general repairs license, the way you read that, if I were a lawyer arguing, I would say, we have the right to, we have a general repairs license, so we have the right to do auto body work. We have the right to disassemble
But
the motor vehicle.
But the ZBA said no. They limited
Right.
the repairs license.
Right, that's
So-
what I'm saying to you. That was, his focus was related to that kind of thing. There is nothing in here, I mean, I guess what I'm saying is, what are we talking about?
But I'm saying that the property owner and its predecessor in title never had the right to
Never.
do general repair work.
To
It may have
do-
been issued a license, but that license was qualified by the ZBA.
By the variance. They never had the right to do body work, disassemble motor vehicles, of that. They did have the right to take apart motors for the purpose of variance. They had the right, I mean, that's clearly spelled out in the 46 variance.
Okay.
And they were given the equipment to do so by the ZBA.
Anybody else have any questions for Attorney Thomas? No? Attorney Thomas, thank you for your time.
Thank you very much for the opportunity to judge.
Do you want to reserve some rebuttal time just in case?
Well, this is a adjudicatory action, so I get the I have the burden, so I get the last say.
Very well. Call Jack.
Well, I would say, does he want to put on anything else before you?
Does anybody else want to speak on behalf of the application, or the petition, appeal?
The appellant.
The appellant.
Just,
Anybody? Anyone want to speak on behalf of Attorney Thomas's side of the argument? No? Yes, sir. Would you come up to the podium and give us your name and address, please?
How you doing?
May I have your name and address for the record?
Stephen Borelli. I'm not a resident of Orange as of right now.
Just give us your address.
12 Partridge Lane, Branford, Connecticut.
Thank you, Mr. Borelli.
My business,
Spelling of your last name.
Borrelli.
Thank
I
you.
was gonna direct you to her, because she
I
doesn't vote.
I have a business that's right in Allentown, and I've been doing business with the repair shop, Mike's Auto over there for 25 to 30 years. They do all our vehicles. They take care of them very quickly for us. They're very valuable to our organization. He's towed many of our vehicles that get broken down. They're not wrecks, but, he takes them in, takes them off the road, gets them repaired for us right away so we can get back on the road and make some money with them. I'm an electrical contractor, by the way. I've seen that operation since I was a kid. I grew up on Baldwin Road, right down here in Woodbridge. I lived in Orange for over 20 years, and it's been a progressing business. I think as everybody knows, we're talking about 1940s and 1950s here, where there was possibly one car in every household. Now there's multiple cars in every household, and there's more cars on the road, more cars that need to be repaired. And I've looked at properties in that area before, and I don't see where any of the properties have been devalued because of that operation. They've all grown. And I just think it's a really good thing that they got a great business going there. I mean, people stop off for coffee in the morning, buy cigarettes, whatever they need, and it's kind of a staple in town, so.
Mr. Borelli, if I might ask, what kind of repairs do they do for you in your business?
You know, a lot of times, tires, they get flat tires. He's done tune-ups on our vehicles, oil changes, things of that nature.
Thank you, Mr. Borelli. Any questions for Mr. Borelli? Anything you want to add, Mr. Borelli?
No,
Thank you for your time.
thank you.
Anybody else want to speak on behalf of Attorney Thomas's side of the argument? Yes, sir. You can please come up to the podium, give us your name and address. Okay, take care. Good evening, sir. If you could
Good
give us your
evening.
name and address, please.
Yes, Kenneth Gambardella. I live at 85 Viscount Drive in Milford. I also own property on 437 West River Road in Orange. I also wanted to express my opinion with regard to Attorney Thomas's argument.
Would you spell your last name for the record?
Yes, sure. It's Gambardella.
Thank you.
I was also a motor vehicle inspector at one time, in addition to many other hats that I wore, and part of my job was dealers and repairs. I did that for 10 years. The town had to sign off on giving Mr. Clements a license for repair work. He has a general repairs license. He actually has 2 general repairs licenses. There was no restrictions on either one of those licenses when they were given to him. He's been in business a long time. I don't think, I understand what you have before you. It's not a straight hardship case like you normally deal with. I think you should give him every consideration, seeing that he's doing his best to try to mitigate the problems that you have. He's trying to get rid of the junk cars. He's trying to relocate. He's trying to find another place to operate out of for the complaints that most of the neighbors here have. And any consideration you can give him. I go there myself. He repairs vehicles for me. And I can't see where he's bothering any neighbors in the neighborhood, other than maybe some extra noise on the outside. I'm sure, you know, if you come to some kind of resolution, I'm sure Mr. Clements would go along with anything to help out the neighbors. He's not there to make trouble. He's there to operate a business. Yes, has the business changed since 1945? I'm sure it has. Anybody who's got a business knows that it needs to grow. So I thank you for giving me this opportunity to speak. Thank you.
Just a couple of questions,
Sure.
Mr. Gamble. First one, 2, actually. The first one is, what kind of repairs have you had done at that?
He's done oil changes for me. He's changed some tires. Whenever I have a problem with the car, when the light is on, I bring it there, he fixes it for me.
And are you the Ken Gambardella that owns the ice cream stand down there that's responsible for 35 or 40 pounds on there?
No. No. But I noticed you've changed yourself.
A little bit. It's good to see you again.
Thank you.
Take care.
Thank you for your time.
Anybody have any questions for Mr. Gambardella as he leaves the stand? No?
Oh, I'm sorry.
That's okay.
No, we're good.
Okay, do we have anybody else who wishes to speak on behalf of the applicant? Yes, sir, come on up. Just introduce yourself and give us your address.
Mark Antonetz, Antonetz. I live on 214 Derby Ave, so right across the street from Will and Mike. Been there about 12 years. Great neighbors. I wake up every morning, I see their shop. Aside from growing a little bit over the years, it hasn't personally bothered us as a family, but always been helpful. They've done repairs for me, my grandmother. So nothing bad to say. I haven't seen anything like spray painting or anything like that. It's just the normal day-to-day. I personally haven't noticed, aside from the growth of the towing operation, and the fences kind of mitigated some of the junk car stuff, which didn't, again, personally bother us. Been great neighbors. I mean, they've helped us, multiple ways. So on behalf of a neighbor, I'll speak for a resident.
And again, same question, what kind of repairs have they done?
Anything from tires, brakes. One time I had my truck in for fuel line repairs, 'cause they were rotting out. Yeah, anything like that. Nothing major. I mean, that's the extent of what we had done personally for my grandmother. She had been there since '64, so I've been with the property since then. So, yeah, just maintenance type work. So,
Thank you.
Yeah.
Any questions for this witness? No? Thank you very much. Anybody else wish to speak on behalf of the applicant? Attorney Thomas's client, Mr. Clements, anybody? No? Okay. With that, I think we'd better call Jack Demerjen.
Sure.
and have you-
Just one more thing before we go. We do have a written
Oh,
submittal
that's
for
right.
someone on behalf of the
I was
applicant. I
gonna
don't
do
know
all
if you
the
would rather read
correspondence.
it now or wait till after.
I was gonna do all the correspondence at the end of the public
That's
hearing,
totally
but
fine.
I
Would
guess
it
it
be-
does kind of fit to
Totally
break
up to
them up
you.
that way. With that said, now that we've had that discussion, there is a submission. I have some correspondence from Martha Cumming, Savarese, of 843 College Street. Says, to the zoning board, dated June 24th, 2024, more than 60 years ago, when we bought our house in this neighborhood, a garage and gas station were a reassuring plus. Over the years, there have been many repairs done well to a variety of our vehicles. The work was well done and the prices were more than reasonable. Gas prices at the pump have almost always been low. Price leader servicing to create a loyal following. Mike has always been considered a friend, as well as an extremely competent repairman. When my car was involved in a skidding accident on an icy road, Mike came to my rescue and expedited the necessary repairs and insurance claims. His work has always been efficient and well done. His employees are always been competent and courteous, and he has been a very good neighbor for all 60 years. Tank replacement is mandatory, but is also expensive and a considerable loss of time and profit, which should be allowed to continue in this place. I'm pretty sure the garage predated the zoning limitations and therefore should not be restricted by them. Please allow this good neighbor to continue his livelihood. Mike deserves our support. He has earned it, with an exclamation point. Respectfully, Martha Cummings, Savarese. I'll submit that into the record on behalf of the petition. Okay. And with that, now it's your turn.
Sure. Would you like me up there? I don't
Yes,
have too
please.
much to
Yes, please.
to add. Good evening, everyone. Jack Demerjen.
Just a second, Jack. Yes? That's coming. Go ahead, Jack.
Jack Demerjen, zoning enforcement official for the town of Orange. With respect for everyone's time, I'm going to do my best to not be repetitive. We've already had ample discussion about the long and colorful history on this property. There have been approvals in the past by this board. There have been denials in the past by this board. Based on my cease and desist order, I am working directly off of the 1991 memorandum of decision from Judge Fuller. we've already had a lot of discussion on item number one, what is light repair work, what is not. I'm not gonna outlaw anybody in this room. Item number two, Attorney Thomas already stated on the record that that is an issue. They are rectifying the wrecked and junked vehicles being stored on the property. And I have noticed in recent months that that has improved. I do have a comment on item number three, and I'm sure we're gonna hear from a lot of residents who deal with this property every day more than I do. While body work, fender work, and painting might not be a main staple of this business, in the past, in my discussion with these neighbors over the last few months, in my own knowledge about the property, again, it might not be an everyday occurrence on the property, but there is body work and painting that has been done here in the past. Again, I'm not saying it happens every day, but for the purposes of this cease and desist order and working off of Judge Fuller's memorandum of decision, I felt it was important to include here as well. So we can get on the record that, you know, while they might not be a body shop, things, you know, maybe a little more than beating out a dent here and there. So I wanted to put that on the record as well, and while we were having this discussion, make sure everyone knew that, again, it's not every day, but it cannot continue in any capacity on the property. So as far as tonight goes, I really don't think I have too much more to add. Obviously, open to any questions that you might have for me.
Does anybody have questions for Jack?
I
Go
have
ahead,
one
Pat.
question. Just circling back to that last thing that you entered into the record. I think it was clear that that particular client had body work done. It was so stated. So there's a little conflict as far as what is said and what is actually happening. So, and again, you can read it again, but like I said, it's pretty clear what that neighbor, even though he's for the petitioner, he does state that that actual work actually happened. So it might be a little convoluted with Attorney Thomas has presented to this board.
I think we can address that tonight.
Yeah.
Right, and like I said, I think hearing from a lot of the other neighbors tonight will, you know, agree with that and break that down again better than I can, as I don't live right next to the property.
Any other questions for Mr. Demerjian? Thank you, Jack.
Thank you, everyone.
Okay, as this is a public hearing, I'd like to ask now, is there anybody that would like to speak against the owner Fuller or Attorney Thomas's argument? Yes, come on up. If you'll just give us your name and address there, and we'll pass out your.
Pass around.
Oh, my goodness.
Sorry. it's
I got
heavy.
it.
You want to, you want to enter this into the record, right?
Yes, I'd
Can you
like
tell
to.
us what this is?
Sure, this is a packet that includes the previous injunctions, documentation of those injunctions. My name is Marie Allen, A-L-L-E-N. I live at 814 Columbia Street in Orange, Connecticut. I want to start by saying I represent a group of 50 households within the Racebrook Estates neighborhood of 67 entire households. And although some of us may differ on what we're asking of Mr. Clemens, we do understand this is a negotiation, and he has a business, and a business that many of us attend, utilize, accept, and admire. Our issue is not with the overall use of the garage or the lifts for repairs. Our issue is with the tow business that operates 24/7, that has not just 6, but as many as 12 tow trucks with different businesses, AAA, New Haven Tow, Mike's Towing, many various tow companies utilizing that property to bring in vehicles that are not in need of a tune-up or oil, or I don't know all the repair names, I'm not going to get them right, but they have no front end. In some cases, they have no fenders. They have broken glass They have parts missing from them that are deposited on Columbia Street, where I live, as the tow truck drags the broken vehicle into the garage area. That is the issue, along with the painting, which I cannot remember if it was 4 or 5 weeks ago, but we sat outside on my back patio to have a barbecue and had to move inside because the smell of the paint was so severe that we could not enjoy our backyard. Those are the issues that we're referring to. Mike's Garage that does repairs, whether it includes more aggressive repairs than a lube job, we're fine with. I think Attorney Thomas is absolutely right in saying what happens inside, he can't understand what the neighbors have an issue with. I have no issue. And my bedroom window faces Mike's garage. I have no issue with what he's doing inside that garage. My issue is with these vehicles that are broken and stacked up, as many as 30 counted vehicles on that property at one time. And if Mr. Clemens is correcting that, and if he needs 30 days to find the proper solution, we're all about that, and we are very happy. But I will tell you that it has been many years that neighbors have brought these issues to the committee, and many times that Mr. Clemens has responded to those issues and made a change that within 30 or 60 days later returns to the original operation. And I think that's why you see so many of us here tonight to say, that piece of it has to stop. We want to be a good neighbor with Mr. Clemens. We want his business to succeed. We all, everyone in this room, just about everyone, I've seen their cars at Mike's place getting repaired. I've said hello to neighbors as we get gas at that place. So that is not the issue. So I want to say that I really appreciate Attorney Thomas's remarks because they're completely aligned with what the neighbors are asking. And although I was not in a crib in 1946 with you, Attorney, and I don't have that background and all of the history, I can only tell you what my 20-plus years of living in a house that is adjacent or actually right across the street from Mike's Auto. And it's our understanding that tonight we're only here to discuss the issue at hand, which is his appeal. There are other issues that some of the other neighbors have, and I know that they'll want to bring them up at another time. But according to the memorandum of decision issued by Judge Fuller, as a gasoline service station, the property is now and has always been in a residential zone, but use of the property as a gasoline service station commenced prior to zoning. The permitted uses, accessory uses, or special uses in a residential zone have never included gasoline service stations or automobile repair facilities. Repairing of motor vehicles has only been allowed in the business and industrial zones, but it's important to note that 217 Derby Ave is in a residential zone. It has been allowed to operate as a non-conforming business, provided that it adheres to the variance approvals of 46 and 55. It's also important to note that some of our current concerns were not present when the memorandum of decision was handed down in 1991. Yet prohibited practices have continued to expand over time in this residential zone, and that, again, is why we're here. The people of Racebrook Estates are asking this committee to support the enforcement of 3 violations listed in the cease and desist order. Any motor vehicle repair or similar activities beyond the limited repair work authorized by 1946 variance violates the Orange zoning regulations, even if it is repair work which a licensed repairer may perform under 14 through 51 of the general statutes. The receipt, storage of wrecked or junked vehicles violates the orange zoning regulations. And I know we did submit photographs of the junked vehicles in the past and would be happy to submit additional if the committee would like. The performance of any body or fender work, including any painting operation, violates the orange zoning regulations. These are violations that have been in place that unfortunately, after many, many years, Mr. Clements fails to uphold these requirements, these regulations, and the neighbors are reaping some really negative consequences because of that. So we're just asking that Attorney Thomas follow everything that he said here at the podium, and that Orange makes sure that he does follow it, not for 30 days, not for 60 days, but in perpetuity, based on what has been decided. Thank you.
Just a moment. Does anybody have any questions for this witness? And so it's my understanding that you're in agreement with Attorney Thomas's position on 2 and 3, which is no body work and no painting. Is that correct? And
Body and painting is
wrecked
one.
vehicles.
Wrecked vehicles and body work.
Yes,
So you-
wrecked vehicles.
You're in
is the-
agreement with his position that if that's not happening there, then you're fine with everything else that's going on there?
If that wasn't happening there, I'd be home having dinner. Yes,
Okay.
correct.
All right, thank you.
You're welcome.
Anybody else wants to speak against the petition? The gentleman in the back, oh, no, he's pointing at the blonde woman. It's your turn.
I've never been called a blonde, so thank you.
Just give us your name and address for the record.
Sure,
please.
it's Michelle Papa, P-A-P-A. I'm at 181 Omen Avenue in Orange, Connecticut. So in that very neighborhood. I just want to address one thing that Mr. Pianza said about the contaminants. And Attorney Thomas had said that as far as he knows, there's no evidence of contaminants or DEP reports. So I spoke with the DEP back in February. Very circuitous way to get to somebody who knew something. But I finally found a supervisor of Engineering Enforcement Division. And so I was talking to him about the wrecked vehicles that exist on that property. And from what he told me, he said the state cannot do ground testing unless we have specific evidence of a spill, which is very difficult to find because I'm not out there when the vehicles are coming in. However, as Marie just stated, they're coming in with no front end. They're coming in totally wrecked where it's clear there's spillage, and we walk the neighborhood every day. And if you look at the property, the evidence, and again, this is only my visual evidence of what is in that ground, is not the same color as what's in my yard. And I understand, my car can leak oil onto my driveway. But this is antifreeze, this is oil, this is brake fluid, this is everything seeping into that land that we can't have checked, or the state can't go in and check that. I don't know who does. But it is a concern for the rest of us because we have wells in that area. I don't personally have a well, but I know the neighbors surrounding him have wells. So, we have spoken with some neighbors to ask if they would get their wells tested. I haven't heard anything from that, but I think the ground, my own personal feeling and that of many neighbors, the ground needs to be tested because I think there are a lot of contaminants over the years and years and years of wrecked vehicles that have shown up on that property. So I just wanted to make that point.
If I may, Ms. Papa, thank you for your testimony. With regards to this particular appeal then, your concerns addressed specifically to the wrecked vehicles and addressed in number 2 of the cease and desist.
Correct.
Okay.
Correct.
And nothing to do with the repair work going on there, just with regards to the wrecked vehicles?
That was specific to, I was actually part of what Marie just spoke about, so we talked about that
Okay.
in drafting it. So, yes, all that, but specifically, I wanted to talk about my conversation with Deep,
Understood.
okay?
Thank you.
Thank you.
Any questions for Ms. Papa?
One question, as far as the wrecked vehicles and the tow trucks, so you also have an issue with the tow trucks?
Oh, absolutely.
So it's actually expanded onto the tow trucks as well?
It is. I'm sorry, I didn't mean to cut you off. Go
No,
ahead.
what I'm trying to understand is that if the wrecked vehicles are now off the property,
Mm-hmm.
the tow trucks would be now mitigated or minimized to just bringing in vehicles that would be in repair.
One
not
can
the
only
wrecked
hope.
bigger. Is that what your intent is?
That's what we're hoping. I mean, we had talked about, I think Attorney Thomas said maybe 2 or 3 small tow trucks, which is kind of what they had. You know, not these tow trucks that can take in boats and, you know, tractor trailers and all of that stuff.
Well, these days, no tow truck is small anymore.
Well, you know what I mean. Like, just a couple
Yeah.
of tires instead of 14.
Thank you.
Any
Thank
other
you.
questions for Ms. Papa? Thank you for your testimony.
Thank you.
Yes, sir. The polite gentleman who deferred to the blonde lady. Please give us your name and address for the record, please.
Good evening. Santo Galatiotto, G-A-L-A-T-I-O-T-O, 170 Oman Avenue, Orange, part of Racebrook Estates. I will reiterate just a couple of points that have been made. I'm not going to go everything. He did a great job. Attorney Marino brought us together in the interest of trying to pull the neighbors together, including Mr. Clemens, and we were, I don't want to say unsuccessful, but we didn't come to an agreement. Meetings such as that occurred in the past. And as was pointed out before, things tend to creep back in. So whatever this board agrees to enforce, we hope that there will be some enforcement that supports our zoning enforcement officer, that we nip it in the bud and we get it taken care of and we don't have to come back to do this again. Attorney Thomas gave a great discussion about the past, and I appreciate that. But one thing that was not brought up was the property where the junk vehicles are served as a barrier, as a border to adjoining properties. There used to be shrubberies there and the like. So he clear-cut that, and now the noise and everything else transmits to the adjoining houses. It was brought up, but I'll just reiterate that Sheffield and Columbia is where their preferred way of bringing the vehicles in doesn't make sense. It's going by Marie's bedroom and Rich's bedroom in the back. They have perfect access from Route 34. We had requested that he seal off the back. Now, I don't know if that's a problem from a fire access standpoint, but I'm just telling you, he put up new fencing, which looks great, but there's still an open area there where the trucks still come in at night. I agree that if the towing operation and the junk vehicles go away, that the activity should go down. But these poor people have been living for years with beep, beep, beep at 2 o'clock in the morning. The neighbor across the street has had to go out there with a broom the next day to remove the garbage that the vehicles have deposited on Columbia Street so his car would not run over it and get flat tires. Attorney Thomas kind of opened the door that I'd like to shut, and that is 24 hours. He said his father contemplated 24 hours but never went that way. That operation has never been 24 hours, except for the towing operation, which came out of nowhere over the last 5 to 10 years. So we believe that there should be some reasonable limits on the operating hours of the operation. And I know that that's not before you today, but you got to consider that the impact that they're operating the way they are is having on the people in the adjoining properties. And as for the paint and body work, I respect Attorney Thomas. He said that he is not aware of. He said that his client has told him that it doesn't exist. But I will tell you, I have observed body work. There's a gentleman in the room right now, I won't mention his name, and I won't embarrass him. But I had spoken to him when we were trying to get together to see what we can do about this, and I said, what do you feel about this? And he says, I really can't speak to it because my truck is being painted there right now. Okay, so that stuff's going on. And the noise. I've mentioned the noise, I've alluded to it. I got to tell you, Rocco sitting right there, when we met with the attorney, Rocco jumped to the cause. He took lights down that were shining in their bedrooms. He's tried to clean up the back. He's done a great job. He's an honorable man. And we respect the work that he's doing. So here again, I'll reiterate, we don't want major work going on there, but we want reasonable work going on there. So I'm speaking to number one. I don't want just anything going on inside those doors because body work is going on, painting is going on. If they had a containment facility, that would be different because then it would be contained. But that's not the case. And that's all I have. Any questions?
Thank you for your testimony. Any questions for this witness?
Thank you very much.
Good evening. Okay. Anyone else wants to speak against the appeal? Going once? I promised you all a chance to speak. Now's your time. No?
I believe we do have one more written.
Yes, we do. I'm gonna make sure we don't have any live people waiting to talk before I read this. It's gonna take half hour. So, yes, sir.
Yeah, right. You don't have plates.
Go ahead, sir. Just give us your name and your address.
Hi, Michael Papa, 181 Omen Avenue, Orange, Connecticut. Thank you for this board for listening to our argument. This procedure's been going on for a while. Jack has been very patient with us, showing up at his door, and we've been in front of this board and a couple of the other boards trying to figure out where we go with this problem to our neighborhood. And, well, we think we're in front of the right board tonight. And we're happy to be here to tell you our issues. The problem is, these issues have come up before, and when they go away for a little while, we take our eyes off of that problem. And we seem to have no recourse once it starts to come back again. Instead of trying, we were told to get our own attorney if something doesn't work. And, in my world, we shouldn't have, our town should be representing our neighborhoods. And I'm in agreement. We like having a local person to tow our vehicle, to our local mechanic that does a local repair job on something when our car breaks down. What we don't like is AAA and towing happening 24/7, 7 days a week. That becomes the problem. And, the amount of vehicles, the density on that piece of property now, if you go back and if you look at some of the photos, we didn't have the privilege of looking at some of these photos that he passed out. But if you look at the density of how many vehicles are on those lots, then look at the density, how much was on there prior to him moving some of these vehicles off the property. It really wasn't designed, to have 60 vehicles parked on that lot, that piece of property. And at the end of the day, that's how many pieces of cars were stuffed onto that small, relatively small piece of property. And so, in front of this board, we ask that, they make the decision to help our neighborhood. We deserve to have quiet, peaceful uses of our homes. And the variances that have been slipped in with trying to get, I don't know about the variances isn't the right word, the use of what this property has undertaken isn't giving us that quiet usefulness of our homes today. And so therefore, we ask this board to side with the neighbors. We're not trying to do anything harmful. We're not trying to take away anything that was okayed to be there. We're asking for the fulfillment of this obligation of this lawsuit that it should still be upheld today. Thank you.
Just a moment, Mr. Papa. Any questions for Mr. Papa? Mr. Papa, I just want to clarify. So your specific complaints would have to do with the towing of the junk vehicles and the body work and the painting being done. Is that correct?
The towing, the oil, and back to, does the town of Orange have the right to say, are there pollutants on that property? Can you answer that question for me?
I can't answer that question because we don't deal with that here.
Can we ask the attorney who represented Mike's Auto Will, can we ask them, will they test that property?
I don't know, once again, if we have authority as a board to do that. What we have authority to do tonight is to determine whether the cease and desist was properly issued, and then what sort of decision we're gonna reach with regards to that.
So in other words, toxicities could sit on that property and nobody will look at it.
That's not our job, I'm sorry.
So, okay. Whose job is it?
I don't know. DEP, I'd imagine.
These are the questions that we ask, and we kind of go around in a lot of circles.
I appreciate
And so
that.
the state doesn't want to see it, the town doesn't want to see it. Who does look at this eventually? And I understand you're not going to give me a rhetorical question.
Well, I'd give you an answer if I had one, Mr. Pop, but I don't. Okay, my best guess, and this is my best guess, is DEP is responsible for that. And as Ms. Papa told us tonight, they need some kind of specific allegation or voluntary compliance. I assume as part of the business, they have some kind of, and maybe Attorney Thomas can help me address this, I'm sure they have some kind of regulations and requirements for disposing of waste oil and things, because they do lubrications there, and that was allowed by the original variance way back in 1946. So I'm sure whatever laws there are, they have to comply with, and I don't know who is in charge of that.
If I could just touch
know
on
we
that
aren't.
for 1 second.
Go ahead.
It is regulated by the state, but it's actually the fire marshal's office that directly deals with DEP on any contaminated issue like that. So the fire marshal would be your point of contact there.
There's a better answer than mine.
Yeah, okay, which will be followed up on. And so you were asking me about what I felt I would be comfortable with.
Well, I'm asking you, your concerns that you're raising, as I understand them, are that they are bringing in junked or wrecked vehicles there, and it's leaving pollutants and debris, and you want that to stop, and that they're doing body work like painting cars and things there, and you want that to stop. Is that correct?
That and the amount of towing vehicles, these large apparatuses that are probably 30 or 40, I don't know how large they are, but they're quite large flatbed vehicles, to tow multiple cars.
Okay.
That seems inappropriate to be on there. It's not a tow truck to tow a car. It's a giant vehicle, and there's 8 of them lined up. So that I'm not quite sure. It seems hard to get in and out just because they're so large and taking up such space on that property.
Okay.
If there weren't 8 or 10 or 12 of them, then 1 or 2 tow trucks would be okay in my world. I guess nobody's going to monitor whether they have 2 or 10 anymore, and I guess that goes back to leaving the parameters wide open again.
Thank you for your
Thank you.
testimony, Mr. Buck. Does anyone else want to speak against the appeal? Yes, sir. Come on.
My
Just give
name's
us your name and
Rich Scanlon, Scanlon, 815 Sheffield. I just want to get on the record of saying, yes, I agree with the 2 and 3. And that the towing, and to the neighborhood's point of the creeping back to getting up to having multiple tow trucks is a big problem. We would like to keep it, small amount, like these guys were saying, 1 or 2 would be great, but then you got these big tow trucks. So I just wanted to get on the record of saying I support the 2 items. As for the repair, Morocco does a great job over there. We love them, and we appreciate them being there. Gas station, all that. So I just want to get on the record.
Thank you, Mr. Scanlon. Any questions for Mr. Scanlon? Thank you for your testimony. Anybody else want to speak against the petition, against the appeal? Going once? Everybody just wants to go home? Okay. At this point, I'm going to invite Attorney Thomas back up for a little rebuttal.
Well, not rebuttal, answer questions.
Okay.
I'll begin with the environmental, to respond as best I can. Number one, in talking to Mr. Clemens' son, when they go out and do tows, obviously, if they're towing a car that's been disabled, and unable to run, that's one thing. There's no police or anything, involved in that. When they were involved with wrecked cars. If there's any spills, those are usually involved with either police or fire or somebody. If there's any spills, they have to take appropriate steps, including a spill pan, and if there are any spills, they have to be reported via the, whoever's on the site, police or. But the other thing, I think, if everybody's driven by the site, as I have recently, you notice that the tank replacements are taking place, which requires a Phase 1 and a Phase 2 in the area of the tank. So if there was any migrating of any contaminants or anything that, it would have been discovered in that, because you have to do it around the tanks. I'm not 100% sure of this. I know you have to do it in the area of the tanks, and you have to do it a certain area outside the tanks. So Phase 1 is a study, Phase 2 is in the ground, in the core. So I just want to alleviate and explain to them that there is testing that takes place that's required. Mr. Clemens did remember Miss Cummings. She did, if you consider repairing her dented wheel and a little bit of a dent in the suspension when she hit it, that's what the work was done, with respect to that. And I've made it clear to them, rather than go back and forth and argue over it, I have told my client, and I stood up here and argued for you the injunction. And I didn't say anything about the fact that those other two items were somehow allowed. They're not. And I've made it clear to my client, since I've been involved in this since about last March, that those two items are not permitted. And I have stressed to them, and I have, Attorney Marino can tell you, I've been heavily involved in land use and enforcement and many other matters, and I've informed him that that's what it is. And my biggest concern was the issue, I don't want to word this poorly, running around in circles trying to identify what light repair work was. And I think what we've seen here, that the main focus is those other two items. And I think that appropriately, I have to inform my client. I can read Judge Fuller's decision, and I can read the other stuff, and it's pretty clear that they're not allowed. But there aren't any, again, I think we're trying to address it, and I've told my clients what is required and how to come into compliance. This is an appeal because, number one, I did not think there was any repair work that was in violation, and I still maintain that. Number two, my client had informed me that they, again, other than a minor thing, they haven't done any body work or painting as you would do in an auto body place. And number three, I instructed him he needed to begin removing, which they've done. And whether the complete, and the tow trucks, except for a few trucks, as talked about, will follow the storage operation.
I apologize for interrupting you there.
No, you're not. Any other questions, I'll be glad to answer them. But-
So I just for clarification, there was a test core done on, at the place
Okay,
as part of the tank.
I can't, I didn't observe any, all I know is that when they're doing tank replacement, they have to do at least the Phase 1.
Yeah.
And in most cases, when you're doing the tank replacement, because you're digging up the tanks, you have to do a Phase 2, and not necessarily a full Phase 2, but you have to at least core all the ways around the tanks and under the tanks to see whether or not there's been any contaminants in the groundwater, contaminants in the soil. And the only reason I know that is I've had a couple of land use situations that have involved service stations, gas stations that are, for instance, been replaced with convenience stores. I've done several of those where they had to do that kind of testing around the tanks.
Thank you, Attorney Thomas.
Okay.
Any questions for Attorney Thomas?
I have one question.
Only from the board. I apologize, Mr. Pop.
One question. I'm going to circle back to a page when Paul Denise was in Jack Demergen's position. There was a case, and maybe you can expound upon this. There was an additional commercial business on that property that they, from what it says here, they cut logs and stored split logs on the property. Does that still exist?
I have no idea. I have no idea when this was. I don't know what you're reading. There's nothing that I was ever given with respect to that.
It's right here. It was sent to Michael Clemens, and it was dated on the 7th day of November, 1994. And it clearly said cease and desist on a secondary commercial business.
I'm not aware of any, just a second, if I can have Why don't you just identify yourself for the record, Michael? Thank you.
William Clemens, 521 Hundred Acre Road, Orange. I have no recollection of that whatsoever.
Well, that's one thing.
Cutting wood or anything of that magnitude, so. once
So
in
in
a-
other words, there is no commercial business on there that does tree services?
No.
Okay,
No.
so
You
in other
oughta
words,
know.
that this document here is inaccurate?
No, this document's from 1994.
Right.
It's not part of what is before you tonight.
No, I
It's not part
understand,
of
I
what
just
you're
asked the
saying.
question, that's all.
Yeah.
Thank you, Mr. Clemens. Any other questions for Attorney Thomas? Attorney Thomas, thank you for your time. We really
Thank you.
appreciate
No
it.
problem. Thank you.
All right, I do have a piece of correspondence that goes in the anti-category. It's rather lengthy. It's from Michelle McNulty, and it is addressed to Jim Zioli, and several other members here, and Jack Demersion. 217 Derby Avenue, attachment 2023-0719, letter petition. Dear board members, we would like to bring to your attention a matter that is impacting our neighborhood in our wonderful town. We know there are a lot of issues that require your attention, but we ask that you please help us protect our neighborhood. We live in the neighborhood next to Amity Middle School. Our neighborhood includes the property at 217 Derby Avenue, which contains multiple businesses. We don't deny anyone's right to use their property and to make a living, but the location of this property is in a residential zone. The violations impact the entire neighborhood, but even more so the residents in close proximity. It is our expectations that the court decisions and the past cease and desist rulings will be enforced by the elected and appointed town officials. There are a few items that are currently under cease and desist order, which will be heard by the Zoning Board of Appeals in July, but those are not the only issues. We would like to provide a brief summary of the judgments and the prior town orders that need to be enforced. Property was approved for non-conforming use in this residential zone, which allowed for a gasoline station, which was started prior to zoning being in Orange. Subsequently, they applied and were permitted for lubrication, tune-up motors, changing oil, and tires. The following are examples of the owner's disregard for the approved uses of the property. 1991 court decision, permanent injunction to stop the following: auto body or fender repair work, painting operations, wrecked or junked motor vehicles, receiving, storing, or repairing them. 1980 zoning violations, cease operations of Skidmore Realty. 1994 zoning violation, require removal of commercial vehicles and equipment cited for illegal parking and storage. Permitted to have only the one commercial combination plated vehicle not exceeding 7,500 pounds. It must be stored in an enclosed garage facility. 1996 zoning violation, required removal of commercial and combination plate vehicles on the property, cut timbers and wood pile. 2003 zoning violation, cease and desist ordered, non-conforming commercial use of residential district property cannot be expanded. Recently cleared and graded property must be restored to its natural state. 2024 zoning violation, cease and desist order, non-conforming commercial use of the residential district property cannot be expanded. Any motor vehicle repair or similar activities beyond limited repair work authorized by 1946 variance violates the Orange zoning regulations, even if it is repair work for which a licensed repairer may perform under 1451 of the general statutes. Receipt, storage, or repair of wrecked or junk vehicles violates the Orange zoning regulations. The performance of any body or fender work, including any painting operations, violates the Orange zoning regulations. The following businesses are operated in this location: gasoline auto repair expanded from permitted scope to major repair shop. Note this business is currently operated, is not part of our concern. Body shop, convenience store, multiple tow trucks, business, Mike's, York's, Amity, all with different numbers, 8 to 12 trucks, junked vehicle storage, road salt storage, currently not there but was for a number of winters. We are concerned about not only what we currently see, but also what else is going on the property. In November, the owner and the town attorney presented plans for expansion of the number of pumps on the property to a group of neighbors. We ask for your help in enforcing the prior judgments and cease and desist orders. We have included a copy of a petition signed last year by the majority of property owners as well as the court judgment. We would like, if you would like copies of the other reference documents, please let us know. Sent on behalf of the residents of the Racebrook Estates, Michelle McNulty, 203-623-8054, and has her email address there. And then there's a letter to Attorney Vin Marino. Can you read that in the record?
I think you could just identify the attachments.
Okay, and this is, an attachment is a letter to Attorney Vin Marino with a petition attached with, I believe, 67 signatures. I think I counted. So we'll put that in the record.
That's all part of the record.
Okay. Anyone else? At this time, we'll close the public hearing?
After the rebuttal, so you can close the public hearing.
Okay. At this time, I'll close the public hearing.
I'll make a motion.
Anybody want a second? Got a motion by Pat, a second by Greg Ladnila. I gotta bring a bottle of water next time I'm reading correspondence. All right, so we're gonna go into our
Well,
session.
first, is there any discussion on that motion?
Any discussion on the
Then
motion?
you gotta vote on it.
Okay, let's vote. All in favor?
Aye.
All right. Thanks, Vinnie.
Yep, that's it.
I know we were paying you to be here for a reason. Okay, first, I want to start, Vinnie, by clarifying something. This is based on, the cease and desist was based on the injunction that was issued in 1991, correct?
Correct.
Okay. And so we're not being asked to go beyond that, or
Well, so it's my understanding, hold on.
we're operating within the confines of that, is what I mean.
Well, let me not get yelled at, all right. Here, mic's on.
He's already waving frantically.
Got it. All right. So what you have before you is an appeal from the property owner of a cease and desist that was issued by your ZEO at warning of 3 issues. The first one is that any motor vehicle repair or similar activities beyond the limited repair work authorized by the 1946 variance violates the Orange zoning regulations, even if it is repair work which a licensed repairer may perform under the statute. Number 2, the receipt, storage, or repair of wrecked or junk vehicles violates the Orange zoning regulations. Number 3, the performance of any body or fender work, including any painting operations, violates the Orange zoning regulations. Those are the 3 bases upon which the ZEO premised his cease and desist. Those were based upon Judge Fuller's decision in 1991 when he entered his permanent injunction. It's my understanding, based upon what Attorney Thomas stated, is that items 2 and 3, they're not contesting. So as a matter of decision-making, it seems like you can sustain those items number 2 and 3 because there's no contest to it.
That's correct.
Right? So the only issue for you is item number 1, right? And that is whether or not you should sustain, actually, let's start with what your authority is, okay? So by statute 8-7, you may reverse or affirm wholly or partially or modify any order issued by the ZEO. So you're not going to reverse and hold because items 2 and 3 have been, kind of acknowledged. So you can affirm wholly or partially that order, or you may modify the order because you're doing this in a de novo setting, right? So it would seem to me, for purposes of efficiency, items 2 and 3 simply you're going to sustain. The question is for you is to determine whether item number 1, as stated, right, any motor vehicle repair or similar activities beyond the limited repair work authorized by the 1946 variance violates your regs. Now, in the prior paragraph in his order, the ZEO says the subject property received variance in 1946 to include, quote, light repair work, but did not include any dismantlement of motor vehicles for the purposes of tune-up and the performance of any body or fender work and in any painting operation or the receipt, storage, or repair of wrecked junk vehicles. That he lifted straight from Judge Fuller's decision, all right? So but it's still, so we know what light repair work doesn't include. So, right, it doesn't include what I just read. What does it include? And, you know, so, I mean, I've heard neighbors stand up and say, well, we're not opposed to X. You know, you're not in a position to say, well, they're not complaining about this, so we'll allow that zoning violation to occur. Right? There's either zoning violations or they're not. It's not what the popularity wants and does. I mean, they can come and seek another variance, right? And you can go through that process. But if if it violates your zoning regulations, you have to be consistent, right? Because the order is not based upon what the popular opinion is. It's based upon what the court's injunction stated. So, you know, it's for you to determine now, you know, whether or not item number one, the real issue is whether item number one, as stated by your CEO, is proper or needs to be modified or reversed. Because if you reversed it, then that would be you exercising your authority to affirm in whole or in part. You're affirming items number 2 and 3, but you're not affirming items number 1 if you disagree with him.
So,
Right.
Vinnie, let me ask you this. If we agree it needs to be modified, does that in fact a remand back to
No, you would modify, because you're acting de novo, you would modify it here.
here?
And now, if you'd like, because you closed your public hearing, there's not a necessity to act tonight. You have a window of time. So you can, if you haven't had the chance to digest the 14-page memorandum of decision issued by Judge Fuller in 1991, you might want to, you know, educate yourselves by reading that. Or if you feel you're comfortable enough to enter a decision tonight, you can do that. But you're not compelled to enter a decision tonight. You can do that at your next meeting, which is coming up.
Monday.
Which is
Yeah.
Monday.
Yeah.
Or you could do it at another special meeting, you know, because I will be on a family trip in Alaska next week. So,
Jack,
you know,
Tell
so.
me this, is there any time limit on, are we operating under any kind of constraint as far as reaching a decision tonight?
No, because we have opened and closed our public hearing, we now have 65
9
days
days,
to
yeah.
come to a decision.
Right.
I
And
just
we
wanna
are,
put that on the record.
yeah, we are meeting next Monday, regardless, because we have another item for our agenda. But if the commission decided they wanted a week to chew on this,
And then
we would be reconvening Monday anyways.
Discuss it further.
Well, let's start there, gentlemen. Go ahead. What do you got to say?
Well, it's interesting, Attorney Marino. One of the notes I made as I read this application was that something is permitted or it's not. So I'm in 100% agreement with you. But
Can you put your
Yeah,
button
you
on?
just turned it off.
I turned it off?
There we
Oh, I
go.
thought it was on. My
The reporter
apologies.
got it, but the public didn't.
Oh, okay. Well, I'll restate that and say, in reading Attorney Thomas's application, I came to a thought that something was either permitted, or it's granted a specific variance, or it's not.
Right.
So I'm in 100% agreement with you. I think everything tonight was very, very valuable. It gives us a lot to think of, and I would be in favor of continuing our discussion on Monday evening.
Yeah, I agree with that. Yeah,
Greg, you're in agreement with that?
yeah.
Eric, you okay with that too?
May I make a motion for that?
Yeah, so.
Do we need a motion for that?
It'd be a motion to postpone.
There's motion to do.
Motion to postpone your deliberations to your Monday meeting. Not a motion to table. It's a motion to
Right,
postpone.
right.
Right.
So, that's- I would like to make a motion that we continue our discussion at our regularly scheduled zoning board of appeals meeting at 7 PM on Monday, August 5th.
Have a second?
Second.
Second by Greg. All right,
Got to vote.
All
now
those in
let's
favor?
take that by the roll. Go ahead, call the roll and we'll vote on the roll.
Call the roll.
If you want to, just go commissioner by commissioner and
Commissioner Panza?
I agree.
Aye.
I agree.
Agreed.
I agree.
So,
Okay, with that, gentlemen, I just want to admonish everybody, we're going to have this discussion next week. We're not going to discuss it in emails and things.
That's correct,
Correct.
Yeah. And the,
Second, I want to thank everybody for their time here. I'm sorry, we're kind of, we need some time to digest this, and we will reach a decision.
ask a
Go ahead,
question.
thanks.
So 2 and 3 is off the table, we're only discussing 1.
I don't think we've made any decisions yet.
Okay.
Pat.
Just-
We're-
I wanted to clarify
All our
that, that's all.
discussions will be
Okay,
Monday
fine.
night. I think that's the best way
Right,
to leave
and,
it.
and he doesn't know this yet, but my partner, Attorney Weaver, will be here in my absence.
Okay.
Okay? So you'll have counsel to speak to
Okay.
in my absence.
Just wanted to know what was on the table and what wasn't on the table.
Well, again, I kind of suggested that 2 and 3 can be sustained, but that's for you to deliberate.
Yeah, understood.
Right.
But I wanted to reaffirm that that's what we were talking about.
Absolutely.
Okay, thank you.
Thank you, everyone. Safe
Thank
trip
you.
home. Good night to everybody in TV land.
Thanks for
Yeah,
you.
they're coming. Everybody's invited back for the public hearing on Monday if you want to listen to our deliberations. You
But
can
bring
come back.
coffee.
Yeah. With that, I'd entertain a motion to adjourn.
I make a motion.
All in favor?
Aye.
Aye.